Everybody knows how to object in court, right? You leap up, yell objection dramatically, the prosecutor faints, the judge applauds, and the case disappears. That's funny. But objection is much more than that. It is not your emotional announcement that something feels unfair. The record does not interpret your feelings. An intelligent objection identifies the ground, requests the remedy, and produces a ruling. What happened? What rule does it violate? What exactly do you want the judge to do, and what did the judge decide? Noise bounces off the record, procedure gets through. Now suppose the court excludes your evidence. If you simply accept that and move on, your evidence may disappear into a procedural black hole. The reviewing court cannot evaluate something it was never allowed to see. That is where the offer of proof, or proffer, matters. Outside the jury's presence, you explain what the witness would have said, what the exhibit contains, what fact it proves, and why that fact matters. The proffer does not automatically admit the evidence, but it saves the proof from the shredder. No proffer? Well, later review may become, what evidence? Exactly. And being overruled does not necessarily mean you lost. You may have lost that immediate exchange, but if the objection was timely, specific, and followed by a clear ruling, you may have created a preserved issue for review. So do not argue endlessly after the ruling. Make the basis clear, request the proper remedy, and calmly ask, "May I have a ruling for the record?" The courtroom moment passes, the record remains. This is one of those areas wrapped in professional mystique, as if objections are secret incantations revealed only after receiving a bar card. They are not. A lawyer may bring valuable training and experience, but the card itself does not operate the courtroom machine. Actions do. Rules, timing, grounds, remedy, rulings, preservation. The rules are written down, the decisions interpreting them can be studied, and sometimes a careful person examining one specific issue will notice something a rushed professional never tested. That's not anti-lawyer, that's anti-magic. And that brings us back to the entire purpose of this court study. Leave belief behind, test the move. Did the objection halt the evidence? Did it force foundation? Did it limit how the evidence could be used? Did it expose a missing connection? Did it produce a finding, a ruling, or a preserved issue? Or did somebody merely perform courtroom sounding words and then declare victory? We are taking this into the upcoming Telegram group calls. Objection by objection, transcript by transcript. What was the authority? Who carried the burden? What evidence was offered? What ruling was made? What entered the record? And what actually moved or halted the court? Because we are not collecting beliefs, we are studying the machinery.